I've been taking my time, taking all of your time, taking all of your time. I've been taking my time, I've been taking my time, taking all of your time, taking all of your time. I've been talking about it for a while. Before we take a chance and do it, before we looking back as foolish. I've been talking about it for a while. Before we take a chance and do it, before we looking back as foolish. We got me floating, and I can take it. You got me floating, and I can't take it. You got me floating, and I can take it. You got me floating, and I can't take it. I've been taking my time, I've been taking my time. Taking all of your time, taking all of your time. I've been taking my time, I've been taking my time. Taking all of your time, taking all of your
Hey, trendies, trendsetters, and my trendy tribe. How are y'all? Mic check, 1 2 1 2. Let me know if you can hear me. Oh, goodness. Double checking just to make sure my audio is okay. Do not trust the knowledges. Can y'all hear me? Possibly. I see everybody. Okay, I see people. Okay, Cynthia said yes. Thank you, Cynthia. Okay. All right. So I'm going to do some greetings and then we shall move on. So let me do some of the greetings real fast. Let's see here. Okay. Well, let me take that off. That'll probably be distracting after a little bit. But Mr. Rogers, it's the reason he's up here. Okay. So Linda Gamble, first in the building. Hey, lovely Linda Gamble. She is part of the Mod Squad. Hey, Erica. How are you doing? Cynthia Arrington. Hey, Brenda Wallace. Hey, Professor Demita Anita Baker Joe is here. Hi, Pink Queen. Hey, Lady Queen. How are you? Hey, Shirley Terry, one of my Leo sisters. Leslie Barber, LB from the LBC. Hey, Leslie. Hey, Uppity Unicorn. How are you? Hey, Anita Wyatt. Hey, Gifts of Wine. Happy Monday. Hey, let's be clear. Joyce Miles is here. Hey, my sweet sis 41 Fits in the house, and we have 5 minutes with Fit today, Mondays and Fridays. She is a content creator and part of the Mod Squad. I see Joy S. Pick. Hey, hold on, going down. Hey, who said that? Hey, Annette GL. Let me see. And Shan, one of my legal eagles, is present. Hey, Shan. She's also in the Mod Squad. Reluctantly. Hey, Ruthie Lewis. Let me see. Sandra Sanderson. Hey, Sandra. Going down. I've seen everybody greet each other. Hey, PN2 Ross in the live squad today. Going down. Let's see. Talking Out Loud is in the house. Talking Out Loud, aka Mrs. Talkative, is a content creator, and she definitely is covering love and marriage hospitals along with other topics I see. But yes, if you haven't heard Talking Out Loud's thoughts, check her out. Hey, Muted Expressions. Hey, Tracy Williams. Hey, Jesse Briley Lewis. Hey, Miss Tina. Hey, Creole Girl. Regina Ashby. Live, Laugh, Love. One of the Mod Squad and my Leo sis. She's also a content creator. If you were like me and need someone to catch you up on Bell Collective, I'm catching up now, but she did her recaps for the episode. So shout out to Live, Laugh, Love. And sis, I got my picture ready to show. Thank you for premiering it. I really appreciate that. Hey, Cinnamon Swirl, also one of my Leo sisters. Hey, Miss Tina. Let me see. I'm going. Aries 66. Hey, Rhonda F. Cynthia Arrington. Going down. Miss Lady One, I see you. I'm going down just a little bit more. I have a tight lunch break hour today. Hey, Jamie. Hey, Mildred Conversations and Cocktails. She's also a content creator. Hey, Harlan Baker. Hey, Mary White. Yes. Hey, Millimeters. Yes. Hey, Lori Harrison. Okay, a little bit more, then I'll have to stop. Hey, Mary Hooks. I'm sorry. And then Kat, Claudia Beard. Did I say hey to Mary White? Hey, Mary White. Guy Needs Love is here. Okay, I have to stop or I won't be able to keep going. Well, dang it, I saw it. Hey, Lil Paulette and the Gang and Pink Diva and Mama V. Pink Diva is also a content creator, and y'all know she mods for Chit Chat. So yes. So Pink Diva's here. I love her voice. She started her YouTube channel. Okay. Let's talk about what's coming up real fast. Next Friday, 5 Heartbeats movie night for the Trendy Tribe members. So I hope to see y'all there if you can make it. It'll be 7 p.m. Eastern Standard Time. Like I said, we got 5 minutes with Fit coming up on this live. And then from our last Sketchy Saturday, we did sickle cell awareness. Shout out to Sandra Sanderson and her niece. Sandra put in a personal request and said, if I didn't mind, could I do that? And she showed it to her niece. She said her niece loved it. And I'm really, really like, cheesing over here. Then Live, Laugh, Love, aka Lady T-Bug. She has started posting the art she commissioned from me because she's rebranding her channel. And so this is what she asked for and approved. We went over it to make sure it was actually going to be something that she wanted. But yes, so shout out to Live, Laugh, Love / Lady T-Bug that's over here just making me just smile more. I don't do a lot of commissions. Commissions are stressful, y'all. I don't do a lot of them. So I just thank you, Live, Laugh, Love, for making it not a bad experience. And I'm so glad to be able to show what I did for you now. I was like, oh, I can't wait. So thank you. Okay. I feel like we're going to have our timeout crew is already in the house. Oh, because y'all going to be cutting up. Okay. Any content I show, I'm just trying to show it for reporting, researching, commenting, and critiquing. Okay. So now, let's see here. I'm getting straight to it. No fanfare because we have a tight lunch break hour for one. So anybody that doesn't catch the beginning, please replay it. It'll be worth it, in my opinion. Strictly my opinion. Okay. Let's see here. I'm sorry, y'all. I can't pre-prep in StreamYard because if I get booted, it knocks everything that I had up out of the studio. So it's like it leaves me with no point, which is very hard to deal with when you're someone that prides themselves on trying to be organized. So I don't appreciate it. Okay, so I'm going to be reading a lot. I don't know how long these documents take, so I'm going to read through the documents. Only pause just a little bit because I don't know how long I got to stick with my hour. All right. Yes, grab some popcorn and ginger. Okay, cranberry ginger ale. Okay, shout out to Girlfriend Chronicles. She is also a content creator and in the Timeout Squad. Okay, so as you can see here, this is the first time we are going over it on this channel. I have heard about them suing them or had a lien on them because of the non-payment. So it's not that this will be the first time. It's not breaking news. It's very lukewarm tea, but I just want to tell y'all what I'm seeing and go over it with you. Okay, so McMahan Drilling and Blasting versus Marsau Scott by name. Okay, the general averments, and I had to look up what that meant. It's a formal statement by a party in a case of a fact or circumstance which the party offers to prove, or why do you do this to me? You stop it. Oh, Don't you do this. Sorry, y'all. I'm trying to see my whole comment. Okay, we're going to keep it moving. I can't see it. Anyway, so the plaintiff McMahan Drilling and Blasting Inc. is a Georgia-based corporation. The venue is proper in this court because the defendant resides in Madison County and the events giving rise to plaintiff's claims occurred in Madison County. So these are the facts as presented by the plaintiff, the McMahan Drilling and Blasting Company. And it says in August of 2022, defendant contacted plaintiff to perform demolition or blasting work at his residence in Madison County, Alabama. Specifically, defendant asked plaintiff to perform blasting work for the foundation of defendant's home. Plaintiff agreed to perform the blasting work defendant requested. Plaintiff provided that it would give defendant an invoice for work it performed once it completed work on defendant's residence. 1 second. Okay, I had to make myself a note because if y'all are watching Judge Million, Judge Mathis, probably Judge Judy, but Million and Mathis are my top two favorites. We know it's bad business to on both ends, if you don't provide a quote of work prior to the work being started. I'm not saying they didn't, but the way the complaint is written, I didn't see that they specified that they did provide like a quote instead of an invoice. And so I just I wonder if they did provide a written estimate to cover themselves from the argument that Marsau would present, in my opinion, this is only opinion, that he would say that he was either overcharged at the end or something. The number is way higher than what we talked about, all that stuff. So I was like, I hope y'all provided a written quote. That was just me thinking about Judge Million and Mathis. Okay. So it says at the time, defendant induced plaintiff to enter into this agreement, and thereafter, however, defendant knew he would not pay plaintiff for the blasting work it would perform at defendant's residence. In other words, defendant knew from the parties' first conversation that he could convince plaintiff to perform work on his residence by agreeing to pay for blasting work, that he would receive the benefit of plaintiff's blasting work, and thereafter he would not pay plaintiff for its work. Plaintiff sought and received a permit from Madison County, Alabama to perform blasting work on defendant's residence. Thereafter, on September 3rd, 2022, plaintiff performed the blasting work defendant requested. After completing the requested work, plaintiff presented defendant an invoice detailing and itemizing the work performed and materials used on the job. In total, plaintiff requested $61,874 for the work performed. Defendant refused to pay plaintiff for the blasting work performed on his residence. And I know people are going to come in later. We're going to have to probably say it twice or more, but I just want to point out that with the time frame of his non-payment, he wouldn't have had all these lawsuits issued yet against him. So if you're wondering, like with all the other stuff going on, why would they even try with him? It seems that they got all of this unpaid work and all this stuff during the same time frame. So everybody wasn't being paid allegedly at the same time. That's how I see it. Because after these, I would definitely obviously be searching your name to see if you have any judgments against you for non-payment, because I need to know when I charge you a 5-figure cost, you're going to pay me. Heck, a 4-figure cost that you're going to pay me. So in case you're wondering about that, a lot of this seems to have occurred from 2021 or 2022. I get him and Story mixed up, so I can't remember if it was all 2022 for Marsau. But yeah, so I just wanted to point that out though. So now they should know because these are all public record. Okay. And then it says plaintiff has attempted to recover those amounts defendant owes it on several occasions to no avail. So count 1, breach of contract. Plaintiff and defendant contracted for plaintiff to perform blasting work at defendant's house. In accordance with that contract, plaintiff agreed to undertake demolition or blasting work at defendant's residence. Specifically, plaintiff contracted with defendant to blast the foundation of his residence. Defendant agreed to compensate plaintiff for the work it performed according to an invoice to be submitted at the conclusion of plaintiff's work. The party's contract is a binding, valid, and enforceable agreement. Plaintiff satisfied its obligations under the contract as described above. defendant has continuously refused to meet its obligations under the party's contract. Specifically, defendant has refused to compensate plaintiff for the work it performed in his residence despite multiple requests from plaintiff. These several refusals amount to a breach of the party's contract. As a consequence of defendant's breach, plaintiff has not received compensation to which it is entitled, been forced to acquire legal counsel, and to institute this action. Wherefore, plaintiff demands judgment against defendant for compensatory and expectation damage in such a sum as a trier of fact may deem appropriate, plus cost of this action. Okay. Hold on. So I had to look up what expectation damage was. It says expectation damages are damages that can be recovered from a contract breach by the non-breaching party. It intends to put the non-breaching party in as good of a position as if the breaching party fully performed their contractual duties. Count 2. Look at that. Fraud. That's what they're a part of their complaint is fraud. When defendant contacted plaintiff to perform blasting work at his residence and thereafter, he represented to plaintiff that he would pay plaintiff for the work it performed. Defendant's representation to plaintiff on this matter was crucial, as plaintiff would not have performed any blasting work for defendant without the guarantee of compensation. But defendant knew from the outset of the party's relationship that he would not pay plaintiff for the work it performed. Indeed, in every instance, defendant represented to plaintiff that he would pay for the blasting work plaintiff would perform, including on September 3rd, 2022, he knew he would not pay plaintiff. Plaintiff justifiably relied on defendant's representation and performed the work the parties agreed to. Thereafter, defendant refused to pay plaintiff for the work it performed, leaving plaintiff uncompensated for $61,874 for the work performed. Okay. Count 3, unjust enrichment. Plaintiff provided defendant blasting services on September 3rd, 2022. It says plaintiff performed this blasting work at the express request of defendant. Before plaintiff performed this work, defendant agreed to compensate plaintiff for the blasting work. Under the circumstances of the parties' arrangement, plaintiff's reliance on defendant's representation that he would compensate plaintiff for the work it performed was justified. Although plaintiff performed the work, defendant has failed and refused to compensate plaintiff and thus has been unjustly enriched. I at first didn't notice that he refused to pay. I kept paying attention to the part that he failed to pay. But as we'll see as we go along, no, he's actively refusing. I was like, oh my gosh. All right, count 4, work and labor done. Defendant owes plaintiff $61,874 for work and labor done for the defendant by the plaintiff on or about November 28, 2022 at defendant's request. The plaintiff demands trial by struck jury. So that's, I looked it up. So this is what the internet says. Trial by struck jury, a jury that is selected from a veneer of usually 40 people from which potential jurors are struck by attorneys for each side alternately until a specified number, as 12, of jurors are left. So that's what trial by struck jury was, at least what the internet said. But look who showed up. Look who's filing this lawsuit on behalf of McMahan. It's Mr. Rogers, y'all. Mr. Rogers is back. I bet when he saw who this was against, when he saw, this is the same person that deposed Marsau on the I do not recall deposition for Zen Gardens. Mr. Rogers represents Zen Gardens, and he has to deal with Marsau again on this case. I was like, woo, child, I'm sorry. I am so sorry, Mr. Rogers. So yes, Attorney Rogers is back. So he's still dealing with the Zen Gardens case, and now he also has to deal with this case. Okay, so now we're moving on to the next document. Let's see. So this is a summons to Marsau Scott. You or your attorney are required to file the original of your written answer, either admitting or denying each allegation in the complaint or other document. With the clerk of this court, a copy of your answer must be mailed or hand delivered by your attorney to the plaintiffs or attorneys of the plaintiffs, and it specifies Attorney Rogers. Okay. And then service by certified mail is how they tried to, or they succeeded in delivering the summons by certified mail. They have a return receipt requested with return receipt attached, which we will look at. And they served it on October 2nd, 2023. As you see, it says see attached. Again, it was by certified mail, and this is the certified mail receipt. As you see, it was addressed to Marsau Scott, October 2nd, 2023 was the date of delivery, and then there's a signature. Black Titanic. Hey, Black Titanic. She said, I just passed Bedrock and can't believe Marsau would buy a mountain of rocks. I'm in Huntsville. You can't believe he wouldn't buy a mountain of rocks at this point. I just don't even know how he honestly acquired even a mountain of rocks. I don't even know. Like, I wondered, is that land, like, are they paying on that land properly? I'm not saying they not, but just wondering. Okay, the next one we have is an application and affidavit for entry of default. So they're trying to file a motion to get a default judgment. This is the plaintiff, okay? And it says the affiant, which is Attorney Rogers, being duly sworn, states as follows. They have personal knowledge of the facts set forth in the affidavit. The defendant was served with a summons and a copy of the statement of claim on October 2nd, 2023. More than 30 days have elapsed since the defendant was served with a summons and a copy of the statement of complaint, and that the defendant has failed to answer or otherwise defend against the plaintiff's statement of claim or complaint, that this affidavit is executed by the affiant in accordance with Rule 55A, ARCP, for the purpose of enabling the plaintiff to obtain an entry of default against the defendant for the defendant's failing to answer or otherwise defend against the plaintiff's statement of claim or complaint. That the defendant is not an infant or an incompetent person, and I know that's a normal statement, but I laugh when I think of Marsau. Not an infant or an incompetent person, and there has been no violation of the provisions of Alabama Code 1975, Chapter 19, Title 5. The defendant is not in the military service, and it says, pursuant to Rule 55A ARCP, the affiant requests entry of default. So I looked up Rule 55A because I was curious, and it says it authorizes the clerk to enter defaults upon the civil docket when the party fails to plead or otherwise defend. Consequently, a party who has appeared can be in default or for failing to file subsequent pleadings or otherwise defend. Okay, so they waited until November 7th to file for this motion. So that gave him more than the 30 days to answer back in writing and according to the rules of the court. Okay. And then it says, entry of statement or entry of default is hereby entered against the defendant Marsau Scott. Okay. The court issues an order that says application and affidavit for entry of default, Marsau Scott, filed by Christopher S. Rogers, is hereby granted. Done this 13th day of 2023. Do y'all think it ended there? It did not end there. Let me tell you, this boy, this person. All right. Hold on one second before I go further. Let me make sure I have my things together because I have just a couple visuals to show y'all. Okay. So now, not only is Mr. Rogers back, Mr. Anderson is back. Mr. Anderson is the representation for Marsau Scott in the Zen Gardens versus Scott. So they're basically facing off through paper again. So it's Attorney Anderson for Scott / Marsau Scott and Attorney Rogers facing off again for this case as well. Okay. So this that we're about to read is Attorney Anderson, which Marsau retained again to answer the default judgment, which honestly, I don't think the default judgment technically is a question, but they're trying to fight the default judgment, y'all. Here we go. All right. So it says verified motion to set aside entry of default. So they're trying to file a motion to make the court set aside the order for a default judgment. So this is what he's claiming is why they can, they want to do this. It says procedural history. Plaintiff filed his complaint on or about September 29th, 2023. On or about October 5th, 2023, a return on service of writ was filed that purports to show Scott was allegedly served with the summons and complaint on October 2nd, 2023. On November 13th, 2023, the court on motion from plaintiff entered default against Scott. Although Scott was aware of a dispute between the parties in July 2023 or earlier, Scott only recently discovered he was named as a defendant in this action. I cannot. Further, although the signature on the form or on the return of service appears to be Scott's, Scott has no memory of signing for the package, never opened the contents of the package, and certainly had no knowledge or understanding that he was being served with a summons and complaint, if he was in fact served with the summons and complaint. Upon learning of this action on Friday, November 17th, 2023, Scott immediately retained counsel to defend the action. Now, he said he learned of this November 17th, 2023. My question is, how did you learn of this if you didn't learn of the fact that your butt was supposed to be in court? And then I just want to go back and say, this was the order. First of all, the order came out the 13th of November, 2023. He's saying he didn't find out until November 17th, 2023. Okay. Then let's look at, this is what I was going to show y'all. So I pulled up his signature from the contract with Zen Gardens and then the signature on the certified mail return, right? And it does not match, but I feel like one of two things, this is totally my opinion, he signed it like that on purpose to make sure it doesn't match so he could feign ignorance. Or a lot of times married couples will sign for each other. Maybe Tisha did a version of his signature. I'm just guessing. I'm not saying she did. And he can then, of course, still claim, well, that's not my signature. I never received this. But in my own heart of hearts, just mine, I believe he had knowledge and he did receive this. That's just my opinion, though. But here's his signature on the top in the white. On the right-hand side is his signature for the contract to Zen Gardens. And then in the yellowish area, bottom right or middle right-ish is his signature or someone's signature on the certified mail receipt. So I was like, all right. Of course he would claim that. I was so not surprised when I saw that. Okay, let me go back. Oh, gosh. Okay, yeah, I see y'all saying no wonder Tisha stressed out. No memory doesn't mean you didn't get it. Right, Diva Kika? Right. Okay, so now we're going to keep going on there. Okay, so this is the argument presented to the court on behalf of Marsau Scott. So they're saying Rule 55C of the Alabama Rules of Civil Procedure provides, in its discretion, this court may set aside an entry of default at any time before judgment. Defaults are seen with disfavor because of the strong policy of determining cases on their merits. To that end, the Supreme Court of Alabama has outlined the general policy considerations when determining whether a default judgment should be set aside. When exercising discretionary authority pursuant to Rule 55C, a trial judge should start with the presumption that cases should be decided on the merits whenever practicable. Now, for me, that part, whenever practicable, I feel like since you busted your deadline, it's no longer practicable. Like you didn't try to answer. It's not like they got their default judgment and you actually tried to answer within the time frame allotted. Then it says the Alabama Constitution and our past opinions construing the default judgment rule support the conclusion that the interest in preserving a litigant's rights to a trial on the merits is paramount and therefore outweighs the interest of promoting judicial economy. Whatever. We have repeatedly held that the trial court's use of its discretionary authority should be resolved in favor of the defaulting party where there is doubt as to the propriety of the default judgment. We have affirmatively acknowledged the disfavorable treatment afforded default judgments on the ground that such judgments preclude a trial on the merits. So basically they're saying they think the courts just tried to handle it expeditiously instead of what's right. Boy, you didn't respond. It says, we therefore emphatically hold that a trial court in determining whether to grant or to deny a motion to set aside a default judgment should exercise its broad discretionary powers with liberality and should balance the equities of this case with a strong bias toward allowing the defendant to have his day in court. Let me go ahead and predict what I think will happen. First of all, I feel like the court will probably deny this motion, but let's say they let it proceed. Like, okay, we'll humor you. I feel like, first of all, he's going to keep doing a motion to continue, putting off the date. Something's going to come up. This court date doesn't work, and they'll do it like a week or few days before the court date. So this will drag on for another few months. Then I don't see how he's going to be able to afford to retain Attorney Anderson. I'm speaking of course, Marsau, in my opinion. And then if they do get in front of a trial, if they don't even have to let him talk, but if they let Marsau talk and that jury gets the energy from Marsau, also with, of course, the facts of the work was actually done, he's gonna lose. So this is like, what are you even doing this for? Now you're just gonna spend more money on attorney's fees. In fact, I wouldn't be surprised if one day I saw a complaint filed against Marsau from Mr. Alan Anderson saying that Marsau didn't pay him for all of his attorney's fees. I would not be surprised at this point. So I'm waiting to see the day that possibly Marsau does not pay Attorney Anderson. Okay, I'm going to keep reading. The Supreme Court of Alabama has established a 3-factor analysis to apply when considering whether to set aside a default judgment. Number 1, whether the defendant has a meritorious defense. Number 2, whether the plaintiff will be unfairly prejudiced if the default judgment is set aside. And number 3, whether the default judgment was a result of the defendant's own culpable conduct. There exists good cause to set aside the default judgment entered against Scott. First, Scott is prepared to present multiple meritorious defenses to the allegations of the complaint. To meet the meritorious defense factor, Scott need not satisfy the trial court that he would necessarily prevail at trial on the merits, only that he is prepared to present a plausible defense. Okay. Here, Scott contends the work done by plaintiff was done improperly and incompetently, and accordingly, plaintiff is not owed any payment or at minimum due to be paid a reduced amount. Additionally, the amount claimed by plaintiff in the complaint is not accurate in that it does not match the amount invoiced. So I would love to see the things that they're comparing, but they're saying that McMahan did a poor job. How ironic. The people that couldn't get Zen Gardens together and had to have a whole nother company and oversight hired to come behind them and actually finish the job, allegedly, is saying that someone did a bad, poor job. Hey, Lala, a bad and poor job on Bedrock. Okay. Second, plaintiff will not be prejudiced by setting aside the default against Scott. Plaintiff will have ample opportunity to litigate its claims, and setting aside the default will permit a determination of plaintiff's claims on the merits. Third, the default was not caused by culpable or willful acts, as Scott only recently discovered he was named as a defendant in this action. Though the signature on the return of service appears to be Scott's, Scott has no memory of signing for the package, never opened the contents of the package, and certainly had no knowledge or understanding he was being served with the summons and complaint. If he was, in fact, served with the summons and complaint. More, Scott promptly secured counsel once he learned of this lawsuit, and he immediately moved to set aside the default. Conclusion, Scott respectfully requests this court set aside the November 13th, 2023 entry of default. The lies. I can't. So that's where they are right now. They're asking the court to set aside the motion for default. The order, I'm sorry, it's an order that was issued. It was already an order of default issued by the court, and they want that to be set aside because are you collecting a check, Attorney Anderson? Because I can only imagine the reason you keep picking this up because you actually getting your retainer, because I do not understand outside of that. I do not understand. Hey, T, talk with your girl. She's a content creator and my sis. Hey, journeyology to the root. Okay, so those are all the documents I have. Let's look at this signature one more time. This is what he said. He said he never received it. Again, like I said, someone from the household could have did a quick squiggly. I don't know. Or he signed it on purpose, different from his real signature. But either way, I, in my opinion, think that man knew he had gotten served. I just don't think for $68,000 in attorney's fees, I want to make sure you got served. Black women are in the building. Also a content creator. She says, now Tisha wants to be a housewife. Nah, miss, I own 85% of Scope. Handle these lawsuits with your man. Yes, my man. Yes. Marsau Rubble knew he hired the company. Hey, Vivian Jackson from Jamaica. Yep. Forever in lawsuits. So there y'all go. That's where we're at. I'll keep you updated. I'm gonna drop the link for 41 Fit, so she could do her 5 minutes with Fit. That way I can stay on task, and I'll keep reading your comments till she comes up too. But oh my gosh, I was like, I was dying laughing, y'all. I cannot live, laugh, love said I'm sick of him using ignorance as a defense. Right, he is the king of I do not recall. They're gonna compare those signatures. They will, but here's the thing. I think he he did sign it in a way that it like the tail of the M doesn't look like he would normally do, but I don't, or he or somebody signed it. I can't say it's him. I don't know. But yes, they're probably gonna compare. But I think even if he didn't sign that, he can't prove that he didn't. In my opinion, he can't prove that he don't owe them their $68,000. At the end of the day, you can say that's not your signature all day. Hey sis, I see you. Okay, I'm bringing you up. Let me see here. Let me get you set up real fast. Just trifling. Where's your background? There we go. Okay. Hold on. Let me get all this stuff out of your way. Oh, getting there. Okay, I'm soloing you out. There you go.
Hey, hey. I'm trying to take this guy off of speaker. Okay. All right. That being said, can you hear me?
I can. If you're
Awesome.
able to do your volume just a little bit more. I don't know if I maybe just have you low. It might be me.
It's me. It's me, Lord, standing in the need of prayer. I'm going to make this really quick. And it really falls in line with what we were just talking about, right? It is talking about really being a person of your word, right? So, bottom row is not a man of his word, right? And he's just not a good person, at least from what he's shown us, right? But we want the trendy tribe, we're good people, we're people of our word, right? And the first thing that I thought about when I saw the topic of what you were discussing is the four agreements. I don't know if anyone here has ever heard of the four agreements, but it's just this concept of just being a better person inside and out, right? So the four agreements start with being impeccable with your word. And these are courtesy of Don Miguel Ruiz. So he actually has a book called The Four Agreements. So the first thing is be impeccable with your word. When you're impeccable with your word, you speak with integrity. You only say what you mean. You avoid using the word to speak against yourself or to gossip about others. Of course, we have some light tea here, right?
Right.
Use the power of your word in the direction of truth and love. So the one thing that we do with reality television is that we learn lessons about ourselves through these people that we're watching on the television. Now it's supposed to be reality TV, depending on who you are in these shows. You are really giving your true reality. Mel is giving her true reality. Kiki is giving her true reality. The Fletchers, in the case of LAMH, they're giving their true reality so we can actually learn. We saw pieces of ourselves in Chris Fletcher, not necessarily ourselves, but children, our brothers, our siblings, things of that sort. So we can actually learn from these things. But the first agreement is to be impeccable with your word. If you say that you're going to be, if for me, let me use this for myself. I'm making a commitment to do 5 minutes with Fit. And I want to be impeccable with my word because I know that people rely on me. Now, trending doesn't need me for this segment. However, it not only helps me out, it helps all of us out, right? Because I want to be impeccable with my word. So the second agreement is don't take anything personally, right? Sometimes we just take everything to heart. And most people don't mean you know what I mean? Most people mean well in everything that they do, right? And so nothing others do is because of you. What others say and do is a projection of their own reality. When you are immune to the opinions and actions of others, you won't be the victim of needless suffering. Look at Tisha. When they had that, like you said, sis, that hot wash, that is such a military term, it tickled
I
me. AAR, after action report, you're actually having a meeting and you're actually
Yes.
talking about those different things, right? So Tisha was not able to accept constructive criticism, right? They're busy giving like an honest opinion of how this can be a better event for the future, but she took everything personally. And I mean, say what you want about Stormy. I mean, she does have product in stores, right? So she does have added value to bring to the table. So does Mel, right? Think about it. First quarter, over $1 million. Are you kidding me? We should be able to take that into account, right? But you have to be able to receive constructive criticism. So again, don't take everything personally. People really don't mean have malice in their hearts, right? Most people. I don't know about them Scots, but I digress. The other thing is don't make assumptions, right? Tisha does lie to herself, Cinnamon's world. She has a concept, right? I just said in the chat, you wanted the pot, sit on it, right? But then don't get upset when people have an opinion of said pot and how you actually sit on it, right? People are
True.
going to have opinions, but don't take it personally and don't make assumptions, right? Tisha automatically assumed, right? She automatically assumed that that Mel, was giving her some information that she didn't need. But the rest of the round table folks said, hey, no, no, no. Actually, and she said, no, no, no. What you're not going to do is reject this information that I'm giving you because
Mm-hmm.
I know it's quality information. So don't make assumptions. We can't make assumptions. Don't make assumptions, right? Find the courage to ask questions and to express what you really want to communicate with others as clearly as you can to avoid misunderstandings. If Trending and I are having an issue, I don't want to make an assumption. I want to say, hey sis, let's chat about it because I feel like, what you said in the chat might be about me. It,
Mm-hmm.
did I hear you wrong, right? But instead of just assuming, and then what the old saying is, you break up assumptions or assume, you make a out of you and me, right? So let's not do that. Let's not make assumptions. And the fourth agreement is always do your best, not my best. You can't do anything for me. Well, you can, right? But as far as your actions and the product of a thing, you have to do your best in your wheelhouse, like another military term. But your area of expertise where you are a subject matter expert, big or small, you can do your best in that area. And again, if you're impeccable with your word, if you don't take anything personally, if you don't make assumptions, then you will do your best in the thing because you're busy sweeping around your own front porch. Yeah, they can't handle the truth, be bliss. That is so true. They can't handle it. And the Bible says that the truth, it will make you free. Because when you are able, it's not an easy pill to swallow. The truth is not, right? It's not an easy pill to swallow, especially when you have ownership of a thing. But you have to swallow it, or you're going to continue to live a lie. None of the trendy tribe wants to live a lie. We want to be good men and women of our word, right? We want to be who we say that we are, right? Hey, ChrissyTyme, love you, girl. But again, those are the four agreements. Be impeccable with your word. Don't take anything personally. Don't make assumptions, and always do your best in your lane. Do your best. And when you're able to sweep around your own front porch and do your best and you bring your piece of the pie, it adds more value to the whole of the pie. All right. And that's really all that I had. And the other thing is just don't be Marceau. So whatever you see him do the opposite.
Right. If this goes to trial, that man, I think Black Titanic said he done wasted his money. Just
Yeah.
should have just paid the actual drilling and blasting company.
Yeah. Yeah, indeed, indeed, indeed. And again, this is from Don Miguel Ruiz. It's called Four Agreements. It's a great read. Again, chew the meat, spit out the fat. If it applies to you, it applies. If it doesn't, it doesn't. But it's something that I try to live by because I want to be a woman of my word, no matter where I am. All right. Thank you so much, Trending. And
Thank you,
God bless
Sydney.
each and every one of you.
Thank you. That was perfect timing. Real quick, y'all, I just want to say, and this is also to my mods, because they be trying to be here all the time. And just so y'all know, I do, well, they know, but I'm gonna say it again anyway. You don't have to be here because we got boundaries over here. We respect boundaries over here, and people got things to do. They got careers and everything. But I think there's a couple things that I need to split up between on my lunch break live and everything. There's a couple more cases I want to go over with y'all. And so because of the thumbnail and trying to make sure I'm clear about what it's going to be about, I may be on multiple times a day. I don't know, not every day, but when there's stuff I just want to share. So y'all already know though. Y'all know my heart. If you're not there, y'all already know I'm okay with it. Because I have to say that though, because they be trying. I'm like, hey, now take a break.
You know we're gonna hold you down like 4 flats.
Yes, because I still want to go over that chef lawsuit that she had put against Diddy. I'm not doing all the other Diddy content. I'm gonna just watch memes and all of them for the other ones. But I got some other lawsuits I want to go over, and so I'm trying to break it up into digestible segments. So, all right, y'all. But that's it for Lunch Break Live. I got to go back to work. And I will see y'all if you join me again. If I happen to go live today, I'll see you later today. Or if not, I'll see you for Lunch Break Live tomorrow. Definitely appreciate you being here. And yeah, thank y'all. Okay, I'll see you soon. Don't even worry about it. Okay, bye.
I've been taking my time, taking all of your time, taking all of your time, yeah. I've been taking my time, taking all of your time, taking all of your time, yeah. We've been talking about it for a while. Before we take a chance to do it, before we